fair dealing is a limitation and exception to the exclusive right granted by copyright law to the author of a creative work. Fair dealing is found in many of the common law jurisdictions of the Commonwealth of Nations. Fair dealing is an enumerated set of possible defenses against an action for infringement of an exclusive right of copyright. Unlike the related United States doctrine of fair use, fair dealing cannot apply to any act which does not fall within one of these categories, although common law courts in some jurisdictions are less stringent than others in this regard. In practice, however, such courts might rule that actions with a commercial character, which might be novelly assumed to fall into one of these categories, were in fact infringements of copyright, as fair dealing is not as flexible a concept as the American concept of fair use. Fair dealing by country. Australia equals. In Australia, the grounds for fair dealing are research and study, review and criticism, reporting the news, legal advice. Parody and satire. Regarding fair dealing under Crown copyright, the Australian Copyright Act 1968, SS 176-178. Section 182A provides that the copyright, including any prerogative right or privilege of the Crown in the nature of copyright, in acts, ordinances, regulations etc., and judgments of federal or state courts and certain other tribunals, is not infringed by the making, by reprographic reproduction, of one copy of the whole or part of that work for a particular purpose. Regarding the reuse of copyrighted images or drawings, the Australian Copyright Act does not impose a 10% limit under its fair dealing provisions for the purpose of research and study. Instead, each and every such use for research or study must be evaluated individually to determine whether it is fair, similar to the notion of fair use in U.S. copyright law. Among the criteria used to determine the fairness of a use are the purpose and character of the dealing, the nature of the work, the possibility of obtaining the work commercially within a reasonable time, the effect of the use on the potential market for the work or on its value, and how much of a work is copied. In 2006, a Federal Law No. 158, 2006, enabled parody and satire to qualify as fair dealing under federal copyright law in certain circumstances. The amendments in 2006 also added a number of other very specific and quite limited exceptions to copyright for personal use of AV material, including those popularly known as time shifting and format shifting. Canada equals. The Canadian concept of fair dealing is similar to that in the UK and Australia. The fair dealing clauses of the Canadian Copyright Act allow users to engage in certain activities relating to research, private study, education, parody, satire, criticism, review, or news reporting. With respect to criticism, review, and news reporting, the user must mention the source of the material, along with the name of the author, performer, maker, or broadcaster for the dealing to be fair. Prior to 2011, fair dealing in Canada was not definitely found to contain exceptions for parody, but the Copyright Act has since been amended to include parody and satire under its fair dealing provisions. Previously, a Quebec Court of Appeal in Les Productions of Anti-Scene Video v. Favreau had recognized that parody could potentially be a critique, however it refused to recognize the exception in that circumstance. The 2004 ruling by the Supreme Court of Canada in CCH Canadian Limited v. Law Society of Upper Canada has gone far in clarifying the concept of fair dealing in Canada. In considering fair dealing, the court makes the following general observation. It is important to clarify some general considerations about exceptions to copyright infringement. Procedurally, a defendant is required to prove that his or her dealing with a work has been fair. However, the fair dealing exception is perhaps more properly understood as an integral part of the Copyright Act than simply a defense. Any act falling within the fair dealing exception will not be an infringement of copyright. The fair dealing exception, like other exceptions in the Copyright Act, is a user's right. In order to maintain the proper balance between the rights of a copyright owner and users' interests, it must not be interpreted restrictively. Furthermore, by taking a liberal approach to the enumerated purposes of the dealing, the court has made fair dealing more flexible, reducing the gap between this provision and U.S. fair use, It then establishes 6 principal criteria for evaluating fair dealing. The purpose of the dealing. Is it for research, private study, criticism, review or news reporting? It expresses that these allowable purposes should not be given a restrictive interpretation, or this could result in the undue restriction of users' rights. In particular, the court gave a large and liberal interpretation to the notion of research, stating that lawyers carrying on the business of law for profit to conducting research. The character of the dealing. How were the works dealt with? Was there a single copy or were multiple copies made? Were these copies distributed widely or to a limited group of people? Was the copy destroyed after being used? What is the general practice in the industry? The amount of the dealing. How much of the work was used? What was the importance of the infringed work? Quoting trivial amounts may alone sufficiently establish fair dealing, as there would not be copyright infringement at all. In some cases even quoting the entire work may be fair dealing. The amount of the work taken must be fair in light of the purpose of the dealing. Alternatives to the dealing. Was a non-copyrighted equivalent of the work available to the user? Was the dealing reasonably necessary to achieve the ultimate purpose? The nature of the work. Copying from a work that has never been published could be more fair than from a published work in that its reproduction with acknowledgement could lead to a wider public dissemination of the work, one of the goals of copyright law. If, however, the work in question was confidential, this may tip the scales towards finding that the dealing was unfair. Effect of the dealing on the work. Is it likely to affect the market of the original work? Although the effect of the dealing on the market of the copyright owner is an important factor, it is neither the only factor nor the most important factor that a court must consider in deciding if the dealing is fair. Though the Supreme Court outlined these 6 criteria, it noted that in some contexts, factors other than those listed may be relevant in determining whether a particular dealing is fair. On June 2, 2010, the Government of Canada introduced Bill C-32, an act to amend the Copyright Act. A summary of the changes proposed by this bill in terms of fair dealing notes that C-32 expands the scope of the fair dealing exception at Section 29 of the Act to include new purposes, education, parody or satire. The stated aims of the revised bill were also to permit businesses, educators and libraries to make greater use of copyright material in digital form. Bill C-32 had not passed by the time the minority Conservative government faced a vote of no confidence and subsequently fell on March 25, 2011. On September 29, 2011, the bill was reintroduced to the 41st Parliament as Bill C-11. With the backing of a majority Conservative government, this version of the Copyright Modernization Act has passed into law. Simply put, the Fair Dealing Amendment in Section 29 of Bill C-11 expands the first criteria for evaluating fair dealing, the purpose of the dealing, to include education, and parody or satire, in addition to research, private study, criticism and review. In a press release on the Government of Canada's Balanced Copyright site, the Honourable James Moore, Minister of Canadian Heritage and Official Languages, notes that the revamped bill delivers a common-sense balance between the interests of consumers and the rights of the creative community. Critics of the bill point to excessively restrictive digital lock amendments that they claim will create a situation where people are entitled to use copyrighted content lawfully but are prevented from doing so. New Zealand. In New Zealand, fair dealing includes some copying for private study, research, criticism, review, and news reporting. Sections 42 and 43 of the Copyright Act 1994 set out the types of copying that qualify. The criteria are perhaps most similar to those applying in the UK, although commercial research can still count as fair dealing in New Zealand. Incidental copying, while allowed, is not defined as fair dealing under the Act. As in Canada, fair dealing is not an infringement of copyright. The factors determining whether copying for research or private study is judged to be fair dealing in New Zealand are its purpose, its effect on the potential market or value of the work copied, the nature of the work, the amount copied in relation to the whole work, and whether or not the work could have been obtained in a reasonable time at an ordinary commercial price. Singapore. Under the provisions for fair dealing in the Copyright Act, Chapter 63 of Singapore Statutes, a certain amount of copying for legitimate purposes, such as for the purpose of research or education, is permissible as long as it is a fair dealing. In deciding whether the use is a fair dealing, the following factors will be considered: purpose and character of the dealing, including whether such dealing is of a commercial nature or is for non-profit educational purposes. Nature of the work or adaptation. Amount copied, relative to the whole work. Effect of the dealing upon the potential market for the work, and effect upon its value. The possibility of obtaining the work or adaptation within a reasonable time at an ordinary commercial price. In other cases, a fair dealing for the purpose of criticism or review. For the purpose reporting of news. For the purpose of judicial proceedings or professional advice would not constitute an infringement. In the case of criticism or review in the reporting of news, a sufficient acknowledgement of the work is required. The reporting of the news could be by any means of communication to the public. It is not an infringement if a person makes a copy from an original copy of a computer program which he or she owns for the purpose of using that duplicate copy as a backup. India equals. A fair dealing with any work is allowed in India for the purposes of private or personal use, including research, criticism or review, reporting of current events and current affairs, including the reporting of a lecture delivered in public. The term fair dealing has not been defined anywhere in the Copyright Act 1957. However, the concept of fair dealing has been discussed in different judgments, including the decision of the Supreme Court of India in Academy of General Education v. B. Malini Malya and the decision of the High Court of Kerala in Civic Chandran v. Amanayama. South African equals. In South Africa, fair dealing is dealt with in the Copyright Act of 1978. Fair dealing itself is described in Section 12(1) of the Act, whereas Sections 13 to 19 explains various exceptions to copyright. Section 20 deals with the author's moral rights, which, if infringed, may also impact on a fair dealing ruling. According to this Act, copyright shall not be infringed by any fair dealing with a literary or musical work, a, for the purposes of research or private study by, or the personal or private use of, the person using the work. B, for the purposes of criticism or review of that work or of another work. Or, c, for the purpose of reporting current events, I, in a newspaper, magazine or similar periodical. Or, e, by means of broadcasting or in a cinematograph film. Provided that, in the case of paragraphs and, I, the source shall be mentioned, as well as the name of the author if it appears on the work. Section 12 mentions both fair dealing and fair practice, and it would seem that these two terms are equivalents. Musical works are compositions, not music recordings. The fair dealing exceptions do not apply to music recordings. United Kingdom equals. Under the Copyright, Designs and Patents Act 1988, fair dealing is limited to the following purposes: research and private study, criticism/review/quotation, and news reporting, as well as parody, caricature and pastiche and illustration for teaching. Although not actually defined as a fair dealing, incidental inclusion of a copyrighted work in an artistic work, sound recording, film, broadcast or cable program doesn't infringe copyright. Since 2014 the UK has protected the fair dealing exceptions from override by contracts or contractual terms and conditions. Contrary to the often stated view, the provisions of Section 29 of the CDPA do not state the amount of an in-copyright work that may be copied for the purposes of non-commercial research or private study or to single copies of the work, where the copies are made by the researcher or student himself. Such restrictions only apply to copies made by or on behalf of a librarian, or by a person, other than the researcher or student himself, who knows or has reason to believe that it will result in copies of substantially the same material being provided to more than one person at substantially the same time and for substantially the same purpose. B. For copying beyond the boundaries of fair dealing, universities and schools in the UK obtain licenses from a national copyright collective, the UK Copyright Licensing Agency. Under these licenses, multiple copies of portions of copyrighted works can be made for educational purposes. The UK is the only member state of the European Union that does not have a private copy exception, since the High Court has quashed the relevant regulations in British Academy of Songwriters, Composers and Authors and Others v Secretary of State for Business, Innovation and Skills. Consequently, now commonplace activities such as format shifting have become illegal. Legal scholars foresee that the said exception will be shortly reintroduced. United States equals. The parallel concept in United States copyright law is fair use. The term fair dealing has a different meaning in the U.S. It is a duty of full disclosure imposed upon corporate officers, fiduciaries, and parties to contracts. In the reported cases, it usually arises in the context of the implied covenant of good faith and fair dealing, which underlies the tort cause of action for insurance bad faith. See also, Digital Rights Management, Fair Use, Limitations and Exceptions, Right to Quote. References. External links, Australian Fair Dealing under Australian law, Fair Dealing in Australia. Fair Dealing for Research and Study in Australia. Fair Dealing in Canada, CCH Canadian Limited v. Law Society of Upper Canada, Canadian Access to Copyright, Association of Universities and Colleges of Canada Copyright Guide, Fair Dealing under UK Copyright Law Explained 2004, Fair Dealing under Singapore Law of 1987, Relevant Sections of New Zealand's Copyright Act 1994, Guidelines for Librarians on the NZ Copyright Act 1994, Fair Dealing in Indian Law, South African Copyright Act, Indian Context for Fair Dealing.